Welcome back to Buzz, and I'm here today with
Catalina Allures.
And I'm Adrienne Houghton, and we're joined by Craig Calley from Calley Law. Welcome.
Yes. Well, thank you very much for having me, ladies.
Now, we wanted to bring you on today because I think it's super important that we make sure people know how easy it is to have a will, because a lot of people out there don't have a will. Am I right in saying that?
That is very, very true.
Okay, so are there 5 easy steps to getting a will?
Well, certainly I'm going to advocate that you go to a lawyer to have a will.
Yes.
All right, certainly from maybe Office Depot or online, you probably can get a will. Whether or not that's going to satisfy all the needs that you have, that's going to be tailored to your own specific needs or not, I don't know. I don't really invest any time in that because I don't make money doing that.
Of course.
But as an attorney, yes, you want people to have a will, and it's really for the people that you leave behind that you do the will.
Sadly.
Ultimately.
How difficult is it to put together a will? Like, if someone decides today, I'd like to create a will, what do I do? What are the things that you would need to bring?
All right. Actually, in my practice, I try to make it as simple as possible. I send a little questionnaire. Well, fair enough. I send a questionnaire by email or mail, whatever the case may be, to the individual with some questions that they need to decide before they come, or we can talk over the phone about them. They need to decide who they want their personal representative to be. The personal representative, PR, will be the person that actually administers their will, make sure that the court has the will, and that that they abide by the I guess the things that are in the will itself.
Can that be anyone, or does it have to be a family member, or?
The personal representative can be anyone. However, they have to be a resident of Florida in order to be personal representative. Can't be under 18. They have to have capacity. They can't be a convicted felon. If they're outside the state of Florida, then they just have to be related to you, and the relationship can be very, very far as a grand stepdaughter. So some kind of connection.
Some sort of. And you can't leave your will to your dog. Like you say, my dog will figure out what to do with my estate, right?
You can't leave your dog in charge of your estate, but you can leave your estate to your dog.
Really? You can actually do.
Really?
Really?
Yeah. Well, ultimately, and there's actually a few attorneys that do that. That's what they specialize in, is basically pet. I don't know if you want to call it
Pet will?
Yeah,
No.
yes,
Are you serious?
Yes.
But then doesn't someone have to take care of the dog, and then technically the estate is taken care of by the person who's taking care of the dog?
And I'll just do a plug for her, Caroline Emery. That's what she does. So I'll just say
For all you dogs out there listening,
yes.
you know?
Call up Carolyn.
Yeah, make sure.
Caroline Emery. I don't do that, but happy to plug for her. Yeah.
So what about like the unfortunate situation where my family had to go through this? When my dad passed away, he didn't have a will. So kind of explain the difference between passing away with a will and without one.
Okay, if you pass with a will, then it is a testate, meaning with a will, testate estate. If it's without a will, it is intestate. If your will is either void or you don't have one, then there are intestate statutes, Florida statutes that govern what happens to your estate in the event that you don't have a will, or the will that you had was not correctly signed, or it's invalid for some reason. It may or may not do exactly what you want, ultimately. So perhaps you don't necessarily need a will because the intestate statutes do exactly what you want, but ultimately the power struggle of who's going to be in charge, who's going to take care of your children, there are a lot of things that are managed by a will that takes the pressure off those that you leave behind.
Oh,
It's
wow.
when my dad passed away and didn't have a will, just trying to sort out all of that afterwards was pretty stressful. So I realized pretty early on in my life like it's very important to have a will, because if someone thinks that that a will is for someone who's wealthy and has all of these things, why is it important for the simple person to have a will? Just an average Joe, I guess.
All right, well, even just if you look at the cost of a will package that I do, which is a will, living will, durable power of attorney, designation of healthcare surrogate, and a pre-need guardian designation. Those are all the things that I consider to be a will package. Just $400. Compare that to not having a will, not having any of those advanced directives in place before a person passes to handle what happens to your person and your property in the event that you lose capacity, which is guardianship and whatnot. If you don't have these advanced directives before you even pass, you've already created chaos amongst your family, because you no longer have the ability to designate anyone to do something for you, either financially or make medical decisions. And then if you further complicate it by passing without a will, then it's, well, who's in charge? Is it the surviving spouse? What if I have a will from before and I left everything to my ex-wife? I have life insurance. I forgot to change a beneficiary. I mean, all these things are better thought of beforehand while you still have capacity, while you're still living.
That's
Wonderful.
great advice.
Oh my
Thank
gosh.
you.
I mean, it's certainly interesting information, and everyone should think about getting a will. And thank you, Craig, for coming on and talking to us about it. And so for all of you who need a will, haven't got one, it's craiglaw.com. No, Calley Law.
Calley
Calleylawcom. So calleylaw.com, and we'll be right back.